Hello friends, Namaskaram, how are you? Myself is Dr. Soni. I am an advocate. Har Har Mahadev, Jai Shiv Shambhu. In today's class, I will discuss an important concern. About Prevention of Corruption Act, I will discuss one of the most important judgment of Honorable Karnataka High Court that is dated 27th of Feb 2026. In multiple classes, I have submitted to all of you that to prosecute a public servant under Prevention of Corruption Act, demand is must. If demand is not established, in that scenario, even though there is mere recovery, mere acceptance, the accused could not be convicted. This is basically one of the most important principle that has been recognized even by Honorable Supreme Court of India. But the basic problem is that whenever we are having the file of anti-corruption, it might be a file by vigilance, might be by CBI, we got panic and might be in the anxiety. But do you think that if you are in anxiety or you are in panic, then you could be succeeded? The answer is no. You have to understand the psychology of the case. Simply, we have to understand certain principle, certain factual scores, and if we are having the factual score along with the legal position in the positive trade side, then we could be succeeded. So basically, in that case, the accused and the co-accused had been prosecuted as per the protocol of Section 7, Section 8, Section 13, Subclause 1, Subclause D of the PC Act. Are you having any idea why Section 8 has been added? Whenever there is a situation on file that one of the accused, who is a public servant, had demanded, and other co-accused, he might be a private person or a public servant, has accepted the bribe. In that scenario, the concerned accused person could be prosecuted as per the protocol of Section 7, 8, 13(1)(d) of the PC Act. But mere recovery, mere acceptance cannot be a basis to conclude that a crime has been committed by the accused person. The prosecution is bound to prove the case beyond reasonable doubt. The accused is required to create a suspect. He is required to give the plausible explanation to the scenario. He is not expected to prove his defense beyond the reasonable doubt. So first of all, we have to ascertain the point of motive. If there is no motive, then we could have the benefit. Apart from that, if the work has been done prior to the proceeding and nothing is on the record to show that the work is pending with the accused, then we could have the benefit. So we have to do the prime attack on the motive. And apart from that, we have to understand the scenario of demand. If demand is not available, and again demand, the statement of complainant are highly inconsistent, or there is lack of corroboration, and apart from that, the complainant turned hostile, we could have the benefit. Because the prosecution is required to prove the case beyond reasonable doubt, as I told you earlier. So complainant is the direct evidence to the concerned incident. If complainant turned hostile, or the testimony of the concerned complainant is highly self-inconsistent, then we could have the benefit. In addition to this, we have to understand that sometime there might be a situation wherein the proceeding is done by the authorities at office, not on the spot. If the proceedings are not going to be done on the spot, it is done at the concerned office. In that scenario, we could have the benefit because the situations got compromised. And apart from that, if the electronic evidences are compromised, there is no specification regarding compliance of Section 63 of BSA. And apart from that, the material evidences are withheld, then we could have the benefit. So in that case, the accused had been acquitted and judgment of acquittal had been upheld by Honorable High Court on ground that the prosecution failed to prove the case. Apart from that, the complainant turned hostile and there is no corroboration on the record. And apart from that, the custody of events or the chain of events are highly compromised. If there is inconsistency, lack of corroboration, the concerned accused could have the benefit. So if you are having the said scenario in your case, then you could have the benefit. And apart from that, if you are at the stage of trial or if you are at the stage of charge, just review your case. Find out what points are weak as far as prosecution is concerned. We have to do a direct attack. For example, if there is no motive, there is no pendency of work, and demand is totally compromised. For example, there is no specification of pendency of work and demand in the transcription, in the verification report, in the consent complaint submitted by the consent complainant at the inception, then we could have the benefit. Simply, we have to understand about our case, then we have to consult with the expert, and then we have to proceed to defend the case so that we could have optimum results on record. If simply we take up our case, simply we engage the advocate, simply we give the file, and we entirely depend on the advocate to contest the case, in that scenario we could not be succeeded. And if we work out in our case at our own level and then consult with the expert, and with the help of proper review, with the help of proper defense, we proceed, in that scenario the chance to win the case will be on the dominant side. See you in the next video. Till then, Har Har Mahadev, Jai Shiv Shambhu.